So it is a general direction.
It's a general direction according to them, according to us.
But theoretically, it cannot be
It can.
implemented.
Theoretically, then, my lord, it is a, what should I say, my lord, it is nothing. It is just like, my lord, my lord, a kind of, my lord, illusion.
Then, Mr. Majumdar, if this goes on the basis of such stand of the government,
my lord, I'm questioning that stand. I have questioned that stand. That report, though, was made available during the hearing of an SLP. There was an order in this matter for direction CBI inquiry. That order was challenged. That order was set aside with the Honorable Supreme Court as subject to correction. And in the SLP, this report was part of the records. And in the, your lordship will find from the report, kindly take the stand of the state in the report, which has been quoted in the order.
judgment.
I'm sorry, my lord. Kindly take, my lord, for once again, kindly take page 673 for once.
Taken a decision to regulate.
Kindly take, my lord, 673 for once. I'm grateful to my learned junior. Kindly take, my lord, the direction. At the end of the memo, copy forwarded to kindly take serial number 5. First, my lord, 2. 1 and 2. Commissioner School Education Department to process the matter in consultation with Commissioner School Education immediately. Commissioner School Education Department, Government of West Bengal to coordinate the matter with CSE, Director of Education on priority. Then, my lord,
no, your stand is that in view of this valid decision of the state, our approval was granted. This is your stand.
Yes. And
now this has been sought to be
diluted. This has been, my lord, the state is taking an inconsistent position.
Now state is against you. State is saying that
I am questioning the stand.
Is the stand of the state against you now?
Absolutely against me. Absolutely against me.
What is their stand? What
their stand is that this is in principle approval. What they did, my lord, your lordship will find from
now take us to that
report. Kindly take, would your lordship would go through the entire report or the quotation from the order?
Portion.
Kindly take the order. My lord, your lordship will find the report in the order itself. Kindly take, my lord, the order at paragraph 20. I will take your lordship to some of the
memo. No, order copy to side ke wait kore
memo ta dun tale hoye jabe.
Acha, memorandum of appeal, my lord. I'm sorry, my lord. Memorandum of appeal would do.
Memo.
Because, my lord, this is such a voluminous.
Yes.
Memo থেকে decide হয়ে যাবে para 20.
দেখেন
my lord has got that.
Para 20.
Paragraph 20. 1920. Down, we have to go. I will take your lordship to the
round
order.
number 20.
Paragraph 20.
Paragraph 20
19,
of the order.
Paragraph 19 and 20 of the order.
19.
For this report purpose.
Yes. The school education.
Yes. The school education department had constituted a committee consisting of Commissioner of School Education, Joint Secretary, Secondary Education Branch, Deputy Director, Grantinate Section, and representative of the DM Darjeeling to cause an inquiry as to how the appointment or approval of 313 candidates as mentioned by the GTA in its affidavit have allegedly been made without waiting for the final approval of the state government through Finance Department and Cabinet, as it was done in the case of appointment of 439 voluntary teachers in the year 2017. The Commissioner of School Education Department, under his letter bearing number so-and-so dated October 9, 2023, had submitted the inquiry report of the state committee before the Principal Secretary Government of West Bengal School Education Department. A copy of the said report was filed before this court, and the analysis and conclusion of the said report is quoted below, which itself would demonstrate the illegality committed in appointing the said 313 voluntary teachers in the name of regularization. But it becomes the basis of the order.
So the state stand is that the induction was illegal.
No, the state stand is that we did not give any approval. That was in principle. I'm reading out the report.
No, don't go to the, where is that line?
Kindly take.
No, but please tell us what was after this order, state memo of 8 March 2019.
Right.
What triggered the state to constitute this
The
committee?
filing of the writ petition triggered the state.
Filing
Filing
the
of the writ petition triggered the state, nothing else.
writ petition is of 2023.
No,
This
this report is subsequent to the filing of writ petition. Constitution of the committee is subsequent to the filing of writ
So
petition.
direction by the writ court, earlier writ court, there was any
There was
direction?
no direction. It was an action taken by the state on its own during the pendency of this writ petition, which has now been partially disposed of. Now kindly take the first paragraph of
No,
the.
that report is against you.
That report is against me.
Very good. What is the ultimate conclusion?
Ultimate conclusion is
is
that
terminate.
no, terminate.
Then the
Recommendation.
1920s holidays.
Page
Page-
170. Page 178 kindly come. Paragraph 21 top recommendation.
20 recommendation, may I just, your lordship is
From
taking
the
paragraph 20, right?
The quoted portion, last recommendation of
Last
the committee.
recommendation is initiation of disciplinary proceedings against the DI.
DI.
What happened? DI retired in the meantime. They initiated a criminal case. The criminal case was registered. My lord, at the conclusion of the inquiry or investigation, my lord, it was found out by the investigation wing, investigating agency, that it is not a case fit for filing charge sheet, so FRT was given. The learned judge says that since the matter is so serious, since a criminal case was registered against the DI, so everything should go at paragraph 21. Recorded in the order. And kindly, my lord, first, my lord, one paragraph from the report I will read, then I will take your lordship to paragraph 21.
So that FRT was not revived or challenged?
Nothing. FRT is absolutely FRT. your
That is
lordship. There was
accepted, that is
173,
accepted.
173.
No, that is accepted.
Yes, accepted. No,
Will accept this. Obviously, they will accept this. Everything is so scam. Anyway,
Scam is again a very interesting phenomena, which is haunting all of us in West Bengal. And my lord, I tell your lordship, in this particular, I will make my submissions now. My lord, it is very interesting. Kindly take, my lord, paragraph A. Paragraph B rather.
Page, that is.
Page I am reading from 20 only. Just paragraph B of the report, where they admit that there is no commission. May I just read it out? It is pertinent to mention here that by an order number so and so dated 5th September 2003, the operation of the Hill Region Office of the SSC had been kept under suspension. But that did not mean that the West Bengal School Service Commission had lost its jurisdiction in the hills. Presently in the GTA area. In the hill area, the SSC can operate through its central commission. This has also been clarified by the School Education Department letter dated 4th or 7th December 2009 to inform the DI of Schools AC, Darjeeling, GTA, that no vacancy can be filled without the recommendation of WB SSC. Was any step, I put the question to myself, was any step taken for last 20 years by the Central School Service Commission or by any other authority to fill up any vacancy in the hill region?
Now,
State cannot.
where is that 7 December 2009 memo referred to in paragraph?
That is not with us. That is not with us.
Hmm.
Malad, they have, but the state may be able to produce it. Right? Now, Milord, now,
July 2010.
Now, Milord,
Now, this report is of 2023.
yes, subsequent to the filing of writ petition. The committee was constituted subsequent to the filing of writ petition. Report was also
Very good. Now,
and
what-
that was without any order of the court. It was the state on its own did it.
so your argument, if we can understand, is that admittedly since 2003 to 2024, there was no appointment of any teacher through the commission because it was suspended.
Right.
Suspension was removed into 9th of August 1999.
No, the hill region was included as a region under the act in 1999
I see.
by an amendment.
Then
9th August 1999. Then,
No.
my lord, after 9th August 1999, my lord, the Regional Commission for Hill Region was established.
Huh.
From 2003, my lord, this particular commission, regional commission or the regional office of the commission was suspended. So, my lord, the operation was act of this SSC Act was kept in a suspended animation for last 20 years. It's a clear case of suspended animation. No, my lord, nobody can point out. Well, interesting.
And you were engaged during that
by
interregnum of
the,
2000,
I was not engaged. The teachers were engaged by the
2003 to 2024.
2007 to 2016. The period is like this.
2000.
But that is within that period, my lord. Within that period.
39 was from 2002-3 and the remaining 313 from 2007-8.
No, just reiterate, your engagement was during the period from 2000, their engagement
Yes.
was during the
313 were from 2007-8.
313 were engaged from 2007-8.
216.
16.
216.
And the 439 were from 2002-3.
No, no, they were from 2007. Why you're saying till 2016?
Well,
By that time,
there are
they had-
different dates of appointment for different
acha,
teachers
acha.
by different schools. Well, the schools were appointing.
Now, this group, over and above this group, there were 439
That is
They
volunteers.
were appointed from 2002-3 onwards.
By the respective schools.
By the schools. All by the schools.
So, for this 439 was from 2003 to 2003 onwards.
2-3, my lord, your lordship can take 2-3.
Acha, they have been regularized
By the cabinet decision.
by a cabinet decision.
Cabinet on 21st of February 2007. 17, I'm sorry, 17. I'm
So,
sorry.
where is this cabinet decision?
But the cabinet decision we do not
No,
have,
sorry,
the
sorry.
dates are
2017, and this memo came on 8th March 2019, which state now
Well,
states
when we found out that only
a
439,
total conundrum.
well, it's not a conundrum.
Total
Well,
conundrum.
it's a question. Well, when we deal with, well, this is a peculiar case, a peculiar facts and
No,
circumstances.
Mr. Mojumdar, you tell us why should we grant an interim
Well, your lordship
protection?
would grant an interim order for the reason that, my lord,
Admittedly,
91
this-
or 92
No,
schools.
just one question.
Yes.
No, that we have understood, that they are engaged in 91 schools.
And
There will be
the
a chaotic
Madhyamik and Uच्च
situation.
Madhyamik examinations are approaching. The date of examination is 2nd February or 9th February. That everybody know. That is within public knowledge. There is no attempt as of now. There cannot be, my lord. The state does not have that, my lord, the genie in the alarm that they will conduct the selection process within 1 month and fill up these vacancies within 1 month. They cannot do. They
Now,
have not done. They will not do.
all right, this is one.
This is one aspect.
No, no,
As-
second, you tell us,
Yes.
8th of March 2019
Right.
memo. If this, I don't know what the learned single judge observed, if it is an in principle memo, these do not confer any right upon you,
My lord,
or
it-
your regularization cannot be sought for on the basis
My lord,
of
but
that.
that is, my lord, on the basis of the stand taken by the state subsequently.
But state itself says,
My lord, state itself, my lord, can state, take a stand contrary to its own memo, contrary to its own writing. I put the question to myself.
why
because-
contrary you are saying? It says state has taken a decision to regularize, but
No.
not implemented as
My
yet.
lord, taken a decision to regularize. My lord, state cannot implement. State can only implement the decision through its agencies and officers. That is why, under the head copy forwarded to, your lordship will find different senior officers of the state have been directed that you do it immediately.
Hmm.
It's not a mere decision. Had it been an in principle decision, then, my lord, this copy forwarded would have been there. But wait, hold your horses. It's not a question of holding the horses. My lord, state had it's a peculiar case. My lord, when we
Now, very
consider
good, do it immediately. Now state takes a volte-face and
Volte-face.
says that the committee we are constituting, now see the committee report.
Now
It
see.
says, then what had been the argument on behalf of the state?
nothing, my lord. The argument of the state is simply submitting the committee report and taking a stand contrary to its own memo. That's the argument.
But in fact, not in
But-
an appeal.
Dump them when you like, take them when you want.
But in my,
Who is for the state?
I led by learned AG, my lord.
Alright.
Virtually, Malad.
Yes, very good. You have now
Malad,
kindly
yeah.
take us to the operative part
Yes,
of
ma'am.
the
May I
order
take your
and
lordship
what
to the-
interim order you want.
Malad, kindly take. Malad, we have the details of the affected schools even. Malad, kindly, I don't want to burden your lordship
That
with
is
that.
91 schools.
91.
And
99.
Madhyamik
Malad,
is
kindly
on
take,
the.
Malad.
Secondary and tertiary, 313 teachers in for.
Malad, may I take your lordship to?
So they are of secondary high
And higher
secondary.
Yes, again. Kindly take the order. Kindly take paragraph 16 of the order. From paragraph 16. Kindly take from paragraph 10. I will quickly run through the order.
No, show us the relevant
Man, the
question
relevant
because
question is
Mr.
Lordship, kindly
Bhattacharya
take
would also be
paragraph
showing.
16 first.
It-
Whether a learned honorable single judge could have done this or not
Achha.
within the scheme of the scheme of judicial committee. Kindly take paragraph 16.
Paragraph at page.
At page, my lord, I
Internal
can give a
page,
lordship the internal page,
Huh.
40.
Yes.
May I just read it out? That apart, the Honorable Division Bench of this court in the case of Kiran Subba versus State of West Bengal reported in 2008 to CHN had the occasion to deal with the issue of applicability of the said Act of 1997 in respect of schools under DGHC. I am not disputing that the Act applies. The Honorable Division Bench, while interpreting Section 15 of the Act of 1987 and the explanation appended thereto has held that the provisions of the WB SSC Act, the West Bengal Board of Secondary Education Act, and all rules are obviously applicable, save and except the explanation provided in the respective acts thereof. In view of the said decision of the Honorable Division Bench, I am unable to follow the decision of the learned single judge of this court in the case of Balkrishna Limbu. Coordinate bench of this court is held that the act has become non-functional because there is no SSC. Act applies. I am not saying that the act does not apply. But for the act to apply, there has to be a commission. For the act to apply, there has to be a regional commission because section 7 of the act provides that only the regional commission can trigger the process of selection.
But if that is so, then during alleged suspension also there was regular appointment.
No.
Some persons have been
No,
given.
no,
You
these
said
are all,
that.
these are all, my lord, volunteer teachers who have been appointed by orders of court. Nobody, no regular appointment during that case, during that period, I'm sorry, during that period.
Means 2003
3
to
to
20.
2020, to even today. We are in at the end of 2020.
So the persons who were similarly situated, they were also appointed in a manner on the basis of the school.
Let us take three sets. One set appointed by orders of court, maybe 100 or something like that. Another set 439 appointed by the my lord, by cabinet decision in 2017. Approved by cabinet decision, whose services were approved by cabinet.
439.
439. Another set 313. That is the present case.
Same manner of appointment.
Same manner of appointment, like manner the first two sets, but left out in the list of.
So order of court and the other is committee recommendation.
No, other is by the cabinet.
Cabinet
Yeah.
approval.
Yes, cabinet.
Bunch of people appointed in 2007. After that long litigation, who are selected in 2002. There was selection was in 2002. There was so many litigations. Ultimately, they were appointed in 2007.
Right. Mr. Ahmed is perfectly right. But that again 2002. Not after 2003. Those are the selection process of 2002.
Very good. They were appointed.
2007.
Then what happened to those appointments? Those are intact.
Those are
That
appointments.
is prior to 2003.
Election process said 2003.
Mala, they could not
In
join.
2003, the 97 Act operation in respect of Darjeeling Hill Council was suspended.
Suspend. Kindly take matter now. Your lordship has gone through matter in the coordinate bench has held. A bench of Justice Shane held that the act is non-functional so far as because there is no commission. But
No.
to the best of my understanding, but whatever little I have learned from your lordships is that when a coordinate bench passes a decision which directly covers the issue in hand, then and if a different view is sought to be taken by another coordinate bench.
But this Kiran Subba is not similarly situated with you.
Absolutely.
That is what
No,
is.
no. Kiran Subba's case is that the SSC Act, West Bengal Board of Secondary Education Act, will apply to Hill region. I am not questioning the application of the Act to Hill region. I am pointing out before Lordship the Act was not enforced in the Hill region for the period commencing from 2003 and till 2024, because now I am told that an office has been set up, but there is no secretary. There is no secretary.
Very good.
I
Now-
am not saying, man, I have no cavil to the proposition of law or the law laid down by your lordships in Kiran Subba. I do not say.
Very good. Now,
May I continue with this order?
entirety you have not to read.
No, only that. Now take paragraph 18.
Yes, yes.
Your lordship will find that the in principle issue was considered in paragraph 18.
Hmm.
The stand of the state was taken note of. But this is a very strange, strange alliance, where the petitioners find ally in the state. Very strange.
Now, what is this 271 voluntary teachers? who were-
We proposed 271, they said it is 330.
You propose GTA.
GTA proposed it is 271. DI conducted inquiry and pointed out, no, it is not 271, it is 313.
Then what happened? Then what?
Then that 8th March memo was issued.
6th March.
8th March, I'm sorry, 8th March. I'm so sorry. That is page 673.
Hmm. The decision to approve.
Decision to approve.
Very good.
Then my lord, approval was given on the basis of, not only approval was given, this entire theory of in principle is not a theory which is tenable before the dishonorable court, because the benefits of ROPA 2019 was extended to each one of them. Each one of the 313 teachers.
That does not create any right
But
in your
that creates a
That would entered anomalous
No, I'm not
situation.
on that.
State is said that you
I am not,
regularize.
I'm aware that does not what I'm on. They say that it is in principle. They say financial concurrence is necessary. When financial concurrence was not given at all, then how could the ROPA 2019 benefits could be extended to these kind teachers? It was financial concurrence not available. So how the ROPA 2019 benefits could be extended to these 313 teachers admitted? Well, kindly take one of the ROPA order 679.
Very good. Now,
These
show us the
Order.
the court's conclusion.
Yes, court's conclusion. Your lordship will find paragraph 18. The court relies on the affidavit filed by the state. The court also notes that the financial implication was yet to be considered. That is why I am showing the ROPA extension. Then, my lord, 19, the school committee, I already placed 19 and 20. Then, my lord, kindly take paragraph 21. What finally seals the deal. The Deputy Secretary, School Education Department, on the basis of the said inquiry report and the recommendation thereto, had lodged a complaint with Vidhannagar North Police Station against the said District Inspector of Schools, AC Darjeeling, and others being Vidhannagar North, PS case number so and so. The said criminal case, though, has ended in final report, but the report of the inquiry committee and the initiation of the said criminal case certainly signify that the regulation of the engagement of these 313 voluntary teachers was done in violation of laws. So, my lord, the report, it is on this basis, these appointments have been cancelled. The report and the initiation of criminal investigation, though the criminal investigation ended in
So
FRP.
this inquiry report is of 9th of March, 9th of October 2023.
That is subsequent to the filing of writ petition. Even the committee was constituted subsequent to the filing of writ petition. Give me the date of the committee, just 1 minute.
No, very good. Now, kindly come read the paragraph 22 first 5 lines.
Yes, I will read my.
I am unable to
I
accept
am
Mr.
unable to
Todd
accept the
appeared
argument
for
of Mr. Kaur. GTA.
Achha.
Man, I am a
Yes.
stepney for Mr. Kaur. He is not available
CPA,
now.
that the government, after extending all
I'm reading, man. After extending all benefits of a regular teacher to the said 313 voluntary teachers, now cannot turn back and say that the approval of regulation for initial engagement of the said 313 voluntary teachers was an in principle approval pending final approval. That being the position, the decision cited by Mr. Kaur, none of the judgments are cited, have no manner of application in the present case. The state never took a final decision to regularize the engagement of the state 313 voluntary teachers. Moreover, there is no question that the state is attacking its own decision. In the present writ petition, or a dispute between the government department has been sought to be settled here. That being the position, the decisions of Raghava Rajagopalachari and the Chief Conservator of Forest
Very
have
good.
no application
Now,
to an-
now show us what were the operative part.
The operative part is, my lord, kindly take the operative part.
26, right?
Yes.
Now,
No, my lord, it is paragraph at the after 29, page 51,
Conclusion.
conclusion.
yes.
Summing, my lord has got that. Summing up the discussion made above, this court holds that the appointment of 313 voluntary teachers in the name of regularization, whose particulars have been disclosed in the supplementary affidavit filed by GTA on April 29,
Yeah, just one interruption.
I'm sorry.
Your engagement was from you.
Man,
said
not my engagement, man.
those engagements were from 2000.
7 to 16.
With the range of about 60.
7 to 16, roughly.
Yes.
Well, may I just read out? Summing up the discussion made above, the court holds that the appointment of 313 voluntary teachers in the name of regularization, whose particulars have been disclosed in the supplementary affidavit filed by GTA on April 29, 2025 is illegal. Accordingly, the impugned letter bearing number so and so, dated March 8, 2019, whereby and whereunder the engagements of 313 voluntary teachers were regularized by the Principal Secretary of Government of West Bengal is set aside and quashed. Well, if it is an in principle approval, if it is not a final approval, then man, everything is also premature. What was the requirement of quashing that memo? Either it is in principle approval, not a final approval, or it is a final approval, I need to quash it. Consequence, my lord, the only interim order which was passed during
So their argument was that since it is an in principle approval,
but it was not their argument. It was state who brought out this argument during the course of hearing. It was not the argument of the
no,
petitioner.
maybe, whatever maybe, but
Yes.
ultimately they relying upon all those sequence.
Naturally,
They argued that
Yes. They are.
yes.
They are.
Now show us what are the other issues left to be considered.
The other issues left to be considered, 439.
That was 439.
439 approved by the cabinet on 21st February 2017.
And sitting aside at the court.
This is an artificial classification.
But this cabinet, this appointment by cabinet was not the subject matter of challenge in the
Yes, everything was under challenge. I think Mr. Ahmed would agree to that. Everything was under challenge. All the appointments, well, let us take
So
one-
all the appointment made in
Kindly take
from
a
on
picture.
and from 2010.
10. Well, their prayer is from 2010. Whatever appointment has been made, you cancel that.
Now, why did they choose 2010?
Because of the DGHC memorandum,
DGN?
that no voluntary teacher should be appointed henceforth.
Oh, I see.
That memorandum, which was reiterated by the
Page
DGA with the
199.
caveat,
Page 199.
199 and 200.
No, that embargo was made in which year? That 2010,
2010.
that embargo.
That embargo.
And this started from 2007.
But they started from 2000, some of them. But I will be very clear to your lordship.
So in between,
But I have to be clear because when I
embargo was from 2010.
Embargo was 2010.
But
Subsequently,
your
he said
engagement of 313 was from 2007 till 2018.
2007 to 18, 16.
Clean from 30.
7 to 18, 16.
Just now
7 to
2016.
Well,
So-
I did not join issue here.
So
Not-
this engagement, what Mr. Bhattacharya will argue, suppose,
Okay.
this engagement is in derogation to page 190.
Absolutely, that is their argument. That is
Yeah.
absolutely their argument. And answer to that
So
argument,
then why you are saying that they have also challenged the cabinet decision
they
pertaining
have
to
not
430?
challenged the cabinet decision, but they have
Yeah,
challenged, they
this
have
is
challenged
their-
everything.
So their argument, your argument
Everything,
is.
everything. After the commencement of SSC Act, everything should go. That was their case. That was their case. Everything should go.
Very good. Now, what are the other connected issue left out?
But 439 is the issue left out.
Uh,
And my lord, coordinate bench decision whether binding or not, that binding precedent or not, that is also left out. And also
now that Kiran Subba has been said.
Kiran Subba is the judgment which the petitioners relied on to demonstrate before the court that SSC Act could apply to the region.
So
And-
that you said it application not
Yeah, I'm
disputed,
not questioning that.
implementation is disputed.
Implementation. So CBI inquiry is left. Na? CBI inquiry is left.
CBI inquiry.
Well, that was quashed by the Supreme Court, but my lord, I believe it was remanded back.
Direction to file a report by CBI.
Right.
In which writ petition?
In this writ petition.
Oh, in this
To
writ.
file
Yes.
I see.
a report by CBI. That was challenging division bench. And there are division bench confirmed the order of single judge. That was challenging SL.
Hmm.
Supreme Court says this is there is no reason assigned. Therefore, set aside. Decide afresh.
Decide
Afresh.
means CBI investigation is not required. That is
At this stage. Says the order was without any reason. Court set aside and remanded. Open remand was made.
where are those orders? Those are annexed.
Now this.
They might be having. But I'm
So
not
then
questioning
what
that.
is the present scenario? That CBI inquiry is no longer there.
Yes.
No.
It was remanded open.
No,
issue
the
is there, but
single
inquiry is
single
not
judge said that
Yes.
there.
The
No,
issue is
single
there.
judge said that there should be a CBI inquiry.
So my lord, that issue has to
Preliminary report was directly filed.
Oh.
CBI filed the report. And in the meantime, at order was challenging division bench confirmed there are.
So there was no initiation of CBI inquiry. So there was a preliminary report called for. That was confirmed by division bench, but Supreme Court said that there is no such requirement.
No. Since the order is without any reason, so remand the.
Oh, now upon remand, was that issue ever highlighted or
No.
considered? Oh, acha, acha.
That is pending for further.
So my lord, 439 and CBI, if I'm not wrong.
And this is after.
And the orders-
One part, only one prayer was taken into consideration and rest has we decided later.
I think
So
Mr.
suppose tomorrow if the court decides that no, 439 is okay, then the entire situation becomes anomalous. Today, that Mr. Bhattacharya will argue. Though you have finished, let us hear Mr. Bhattacharya. You are the persons who have been.
But if reply is required, my lord, I will make.
Please come to the operative portion of the order.
But only one point, just one thing. The only interim order which was passed during the pendency of repetition is that no further appointment of voluntary teacher should be made during the pendency of the repetition, right?
There was
In this repetition.
in this was an interim order, not to regularize any further, because during pendency of the repetition, further regulation was being done.
Further
Now
regular-
there was complaint of court has passed an interim order not to regularize any further.
So, my lord, that order, my lord, I am not opposing.
Naturally, you will. That does not give you a feather in. Yes, Mr. Mojumdar.
Please
No,
come to the conclusion.
if we hear Mr. Bhattacharya, then you can.
Try to reply to.
Also, you tell your points. You are for these candidates.
Come to 330.
Now, give us this picture. Writ petition was filed impleading you.
No.
No. Subsequently, you
We got
intervened.
We
So.
got ourselves immediate through application.
So all 313 are involved here now. So you are appearing for those teachers.
Some of them. 121 or 131 have referred an appeal.
And others are also represented by some other council. No?
It has not yet been filed, but they are in the process of filing that.
You are representing which respondents here?
Not that 130 to 132. in the
13.
petition.
Yeah, you are 30 petitioner you are respondent number.
13 to 132.
Yes.
Now, please come to the operative portion of the order, the conclusion. But what is the necessity of passing an interim order today? Summing up the discussion, the court holds that the appointment of 313 voluntary teachers in the name of regularization, whose particulars have been disclosed in the supplementary affidavit, is illegal. Accordingly, the impugned letter number so and so dated 8 March 2019, whereby and whereunder the engagement of 313 voluntary teachers were regularized by the principal secretary, is set aside and quashed. Now the court proceeds on the basis that this is not a case of regularization, but a case of fresh appointment.
That is your argument.
No, that's not what the. Please come to paragraph 10 of the judgment. The court holds it to be a case of fresh appointment. Please come to paragraph 10 of the judgment.
So the court's mind was that these persons who have been appointed shall not be regularized.
But one is what was 8 March 2019 purporting to.
Your appointment is bad, so court said that don't regularize.
We were appointed, that has not been set aside. We were appointed long back from
No,
2007.
how can the different dates of appointment can be chosen up and then court will say
Regularization is all, of course, prospective. It's not going back to an anterior date.
if the regularization goes, your engagement
No,
goes.
please come to not the order first. Can you test not the exercise which was undertaken? Two documents I shall just immediately show to your lordship.
So your argument is that regularization has been set. You set aside regularization.
So we go back to the status of voluntary teachers
Eh,
drawing a consolidated remuneration of 2,000 to 3,000 rupees per month.
no, you are drawing a regular employee.
Now, what is the impact of this order of setting aside the regularization?
Impact is that you go back and enjoy salary which is to be given by the respective schools.
So that consolidated amount of 1,000 or 2,000 rupees. Now please come to two documents at pages 360 and 363 in my volume 3.
360 and 363 is the
It's in my sheet. Item number 8.
not what is the what is the document? Tell us no.
That was the factor which was taken into consideration consciously before directing regularization. Regularization in service is not a foreign concept. Now, two points were made in the writ petition. One, we had been appointed through a procedure not in accordance with law, number one. And number two, we did not possess the requisite qualification. Now, these were the two foundational bases for challenging these appointments. But as of today, everybody is qualified. I shall refer to the government order in this regard.
As per plan. Yes, 260.
360.
What is your showing?
Now, this is not the data dated 24th of April 2018.
2nd July 20th.
So,
Page 363.
360. But your Lordships are probably looking at the Administrator Abrodosh Majumdar's please take a note.
Dino, yeah, 360.
No, Shugan Vishwakarma.
Yes, please come to 360, not the pagination within brackets. Volume 3, page 360. Okay.
360, 24 for 2018.
I'm grateful. Now it's Assistant Secretary to the Government of West Bengal in the School Education Department writing to the DI of schools in Kalimpong and Darjeeling. The undersigned is directed to inform that a proposal has been received in the department for regularization of 271 volunteer teachers said to be serving in different government aided and government sponsored schools in GTA areas list enclosed. It is now requested to cause verification of the claim for regularization of these persons on the following criteria. 1. 3 years teaching experience. 2. Possession of requisite qualification. C. Knowledge of Nepali. D. Knowledge of relevant subjects. E. Letters of engagement by concerned school. F. Existence of sanctioned vacancies.
So these were the criteria laid
These were
down.
the criteria which were to be verified by the concerned department before finalizing this regularization. And which one of these factors will your lordships find is defying any law?
In defining,
None of these factors is defying a law of regularization. These are the essential factors.
so naturally, if question of existence of sanction post ought to have been there.
That's there.
then
That's
the
serious. Please come to now page 361. These were there. Now please come to page 361.
GTA
Yes,
resolution.
the administration. No, that 30th July 2010, which had been tormenting your lordships, that was not to be given effect to any further.
Where you
But the third paragraph on that page 361. The meeting commenced with the board approving the proposal for regularization of volunteer teachers in secondary schools, a special case which has already been sent to the Department of School Education, Government of West Bengal. The order dated 30th July 2010 and order number of 25th June 2018 shall not affect the decision of the board.
So how does that help?
So the 2010 embargo was lifted. Insofar as regularization of those already appointed teachers are
No,
concerned.
according to you, is it a relaxation of the
Relaxation,
embargo?
that's
So if your submission is submitted, accepted, it is a
it's a
relaxation.
relaxation. So not the complete embargo which was once imposed was relaxed in 2018. And this exercise of regularization was to be done on the anvil of page 361, wherein the factors were adumbrated.
Yes.
Now, please have a look at 363. Now, DI writing to the government, DI, of course, is a person on deputation in terms of the provisions of the GTA.
Very good, Mr. We understood.
As per instruction, the voluntary teachers of the government aided and government sponsored schools have been physically verified by the DI of schools, GTA Darjeeling, along with GTA representatives on their school premises by considering all criteria laid down in your letter of 24th April 2018. The said list is being forwarded to your good office for your kind perusal and taking necessary steps for regularization of the volunteer teachers, considering the necessity of the teachers and schools.
So this 271 is amongst 330.
Now, this list was ultimately found to be 313 on physical inspection and applying the criteria at page 360.
Where do we find that?
No, that's in the 313 list. No, that your lordship will be pleased to find. Please come to page 365.
Yes.
Same day. After careful consideration and deliberation of the letter of so and so, from the Principal Secretary School Education Department, you are hereby directed to issue necessary order on 4 issues mentioned above. Letter of appointment or approval to the 313 voluntary teachers in secondary higher secondary schools who were found eligible after strong departmental verification, whose lists are enclosed herewith. Appointment or approval letter to 59 volunteer teachers of upper primary schools whose lists are enclosed therewith, to take necessary action to approve the recognition of 14 schools whose lists are enclosed therewith, in issuing of appointment or approval letter to the 4 teachers whose recommendation letter has been revoked. The entire exercise undertaken in 8 March 2019 has been set aside.
All right. Now,
I just showed you the stand of the state government. Now, there had been vacillating stand. Now, please come to only 2 documents. Please come to page 531, 535. It's the 4th volume.
of your matter.
Okay. But within first bracket, pagination is 535.
This affidavit of state.
Yes. But in a review application before a division bench in another matter, this was the stand taken.
Review
Then
application.
in some other matter which went up not from single bench order, but this is the stand taken by state.
Against the some other.
Some
Yes.
That's internal page 9 of that,
So this is not their stand here.
not the stand here. But I just showed what is the stand. Please
Then
come,
no, state said that this is their stand.
yes, please come to 535, paragraph 11.
Yes.
It is apparent from the notification of 1st October 2012 passed by the Department of Education that the GTA, being an autonomous body, has administrative control over the government and non-government state-aided schools. Thus, it is the GTA that has the jurisdiction to consider the representation made by the petitioner for being appointed as the headmaster of the Darjeeling Hindi High School of so and so. From paragraph 16. It is submitted that the Honorable Judge fell into error apparent on the face of the record in delivering the judgment and order dated 20th November. Inasmuch as the Honorable Judge did not consider that after ceding all its powers in favor of GTA by the notification dated 1st October 2012, the applicant number 2 or any other official of the School Education Department of the Government of West Bengal do not have any authority in connection with the service conditions of the petitioner. And that's exactly not the purport of section 26 of the GTA Act 2011. Let's say,
So you are saying now the memo of this 8th of March 29 is inconsequential.
the 8th of March 29 is directing
2019.
regularization.
Huh?
Is directing regularization.
Yes, that is in because state, if they do not have the power to undertake that issue, as per their stand, it is for the GTA to
It's not
consider.
subject to the law says subject to approval or order of the government.
Hmm.
That's the language in section 26 of the GTA Act 2011.
Hmm.
Now, not ultimately the fund comes from the government. So in-
Ultimately, so how can the state say that it is no longer my child, it is
No.
your child?
not from man to man, door to door verification. That not same, not our court's employees. Not when a requisition is sent by the court administration to the government.
That is hard, whether there's those are factual issues.
Yes, those are factual issues. Not that is why I argued before the Honorable Single Judge that although the School Service Commission Act may apply to the territory of the Hill region under GTA, but going by the specific provisions of the 1997 Act, this will not apply to these particular schools.
Why?
Please have a look at section 15 of the Act.
A definition of school.
Now, definition of school has something else. Section 15 specifically excludes certain categories of persons and schools from the purview of the Act.
So then if you exclude yourself from that purview, then how do you get revisional benefits of the
That-
state if the GTA has not?
Not one is applicability of SSC. Not two on two grounds. Not this was argued by the petitioners. One, procedure was not followed. Number two, eligibility.
Hmm.
As of today, eligibility is there. In fact, ROPA 2019 takes care of this eligibility clause. One who had not obtained B.Ed training at a particular point of time has been given 5 years relaxation for the purpose of obtention. Non-fulfilling this program entails certain loss of incremental benefits.
Hmm.
That's nothing more. Now, in so far as that other aspect is concerned, I shall argue at the final stage. Subbarao does not answer that question. Kiran Subbarao's judgment does not answer that question. It was on the perspective of applicability of linguistic minority vis-a-vis the SSC Act, but not in the final hearing. Today, the situation is a situation.
No, I didn't follow your argument that it is from the affidavit which you have showed just now.
Yes.
535.
I know.
The stand of the state is what? Your stand of the state is I don't have anything to do.
In principle, approval is granted.
In
now-
principle, approval is granted. Now you pick up who are the persons competent.
You find out the persons who are competent. Now, not this threadbare exercise carried out by the GTA through the deputy person on deputation from the state government.
But what do you say about this? The 2019 decision of government was not approved by the cabinet. It is still kept in abeyance.
No, please have a look at. That's why I showed to your lordship, which is 361 and 363 as well.
Yes.
Now, those are documents from the government itself.
No,
Please come
very
to
good.
360.
Government has said that you find out those persons.
Please come to 360.
Whether they are sanction point.
First is not laying down the criteria.
All right, Mr. Mujumdar. Now let us hear Mr. Bhattacharya. In reply, if you want to give it. Yes, Mr.
I'm not
Bhattacharya.
the first and foremost. Not who are the first and foremost question is not who are the persons challenging these appointments. None of them was qualified in terms of this memo of 2018.
2018 memo means
360, page 360.
which you 360 which you showed.
Not one is a student.
360 15 persons came.
Yes.
15 writ
Not
petitioners.
most of them were not qualified in 2018 even. Some of them has completed his graduation in 2021.
360.
360. These were the qualification.
You see, 3 years experience.
Yes. One comes from Nodia. One is a student.
Your engagement was last in 2016,
Yes.
from
Yeah.
7 to 16. And you are in secondary school, so you
Secondary
should be
school.
graduate. So you should be graduate with B.Ed.
Yes.
You don't have B.Ed.
As of date, we all of us have.
All of us.
313 has
All-
B.Ed.
All of them.
Now, please come to your lordships were questioning about the phases of recruitment or not regularization. I think that's a summation at page 383 of my brief.
Yes.
383.
383.
What is that?
The 29th of April 2024.
Yes.
This is to bring to your kind notice that a detailed exercise needs to be done to gather information along with supportive documents of teachers whose services had been regularized in different secondary schools, both in DGHC and GTA periods, as instructed by the authority of the GTA. The information may be required in the subsequent stages of hearing of WPA number so and so. This is for your information that a report has been obtained that reveals that the services of the numbers of teachers had been regularized through DGHC as well as GTA period as follows: 2010 42, 2011 107, 2012 269 plus 11 volunteer teachers, 2017 16 volunteer, 2017 302 plus 137 439, 2019 313 volunteer plus 59 new set of schools plus 129 ad hoc.
So this does not refer to the 2000 memo which has the 8th March memo of 2019.
The last one, 2019 313 volunteer.
Acha, acha. So what is your contention?
But this is how not we serial number 5, 6 stand on the same pedestal as the persons in 2010.
Those who were approved by the cabinet.
Yes, same process.
Yes, Mr. Bhatt.
Now, not only to show that 2016
Now, my
recruitment process excluded hill region.
Yes. It into another report. Yes, Mr. Bhattacharya.
We are at the stage of consideration of interim order. The fundamental question, I am not going to trouble my lord with the facts at this stage. Would the rule of law prevail? Would the constitutional provision prevail? Or somebody's whims will prevail? How could these people come into service? What is the source of their recruitment? Kindly go to the source. They were allegedly all voluntary teachers appointed by some of the school managing committee. Was there any application invited that volunteer teachers would be appointed? You please come and join. There lies this question of scam. Scam is not just a mere word. And these teachers who entered through a completely illegal backdoor method are now being sought to be regularized by the state. Can the state regularize this? All these questions, School Service Commission, these are all secondary issue. Primary issue is if they are fast entry as teacher, so-called voluntary cheaters, is in violation of basic principles of law. State cannot, regularize them. GTA is not, beyond statutory provision. That's why state ultimately had to say these appointments are illegal. We cannot approve this. None Advocate General.
Where has that been stated? Illegal appointment by?
That's why the proceedings, Learned Advocate General appeared, and that is recorded, I believe. I am handicapped because all the papers are not with me. That's why state had lodged a criminal complaint against his own officers. Whether that ultimately comes to a final report or not, that's a different issue, and the investigation has been directed by the court to continue. If the original source is vitiated by law, subsequent regularization by the state or the GTA is not permissible. Public fund cannot be utilized by any means for an illegal purpose. Now, at this stage, the question might come, the sentiment might be arose saying that what would happen to students? Now these schools are on holidays. Let the main appeal be taken up after reopening. On the first day, I am prepared to argue the matter in detail to show how these illegalities have been committed. Now these schools are closed. For these 7 or 10 days, nobody is going to suffer. And even if your lordship may please to consider, if necessary, GTA or the government can appoint the retired teachers who are regular teachers, their services can be explored for the students' benefit. But not allow these illegal appointees to continue, which avoid ab initio. I'll kindly fix it up on the reopening date, any date which suits your lordship's convenience. I shall attend physically and show the facts which are obnoxious facts. And another 436, if it is taken up, all will be disallowed by the court. Court by no imagination can allow the illegal appointments at the entry point. Regularization means you are regularizing somebody who had initially appointed legally, but maybe through irregular process. But everything is illegal. Umadevi is staring at our face.
So one question, Mr. Bhattacharya, the court says that for the time being, I am setting aside this memo and the other issues I will decide later. Now,
yes,
today,
today,
Mr. Bhattacharya, if after deciding, if we say we are not interfering, in that case, what happens to the writ petition pertaining to the other employees who are still subsisting?
That was considered, not considered by the court on the prayer of the parties. The prayer of the parties was kindly that 313 appointments were being considered, therefore let it be confined to 313.
Mr. Bhattacharya, if we accept your contention, then this direction is untouched. If this direction is untouched, and after reopening the matter is heard pertaining to the other issues which includes an issue of appointment of the further teachers who are done, then in that case, the same bench, how they will be tackling, then it is a decision which is remaining those issues pending. I am saying that the parent order is bad. But in that case, what remains to be decided in that?
Nothing, to me, nothing remains. Your lordship is right. But this 313 is not dependent on 436. This is not the case that 436
but
has
Mr.
been done.
Bhattacharya, your challenge against those 436 also
remains.
Is of identical issues.
Yes.
That there was no post backdoor appointment inducted.
Right.
So today, Mr. Bhattacharya, this is upheld. Then what remains to be decided in the other round of litigation before this?
Legally nothing, but factual aspects should be there. They might come out with the different facts. But legally, your lordship is 100% right that this principle will equally apply so far the 436 is concerned. But staying at this stage would be without giving premier to the illegalities. My lord will not kindly give any premier to illegalities. This is creating very bad precedent for the society.
No,
let the appeal be heard out. On merit, let us see what happens.
But today, if it is left untouched, their service goes.
They have to go. But they, by allowing them to continue by virtue of the interim order after a proper adjudication would give them the premium.
Then you should have said that you decide everything together. Don't make
All
compartmentalized.
we have, that was our prayer. That is our prayer. That was our prayer.
No, no,
But
I
will not
suppose
be-
in the another appeal, one order of 2nd December has been challenged, wherein the application was for maintainability of the writ petition itself.
Yes,
That issue
that
has
is
also been kept open.
no, that was decided.
No, maintainability issue
Ah.
was not decided.
It has been decided, thoroughly decided.
313 has to be decided first.
Well,
Prayer.
everything has been decided. Let the judgment be
Maintainability has been decided.
No,
Yes, yes.
Lordship, may I submit?
It has
No,
been
tell
decided.
us yes or
No,
no.
Lordship.
So is that point?
Filed an maintainability application.
Who are you?
Lordship, I am the appellant in MAT
Teacher.
106.
Teacher.
Two teacher. Two voluntary
One of the
teachers.
313 teachers.
One of the 313 teachers, Lordship, who has made an application
For
for
maintainability.
addition of parties, seeing Lordship the paper reporting. In paper, Lordship, 300.
They're very good. Now maintainability point, where from it comes?
I have made an application, Lordship. It was never heard on second.
No, this is wrong.
Please, let me complete. Please let me complete.
Yes, yes.
Don't
you say-
mislead the court.
I will be showing documents, sir. On 2nd December, Lordship, while rejecting my chance to reply, it was held that the maintainability application will be decided at the time of final disposal.
Show us that line.
Lordship,
We appealed her, we ordered her. That order must be here also.
Lordship, Lordship.
313 teachers. Hello, Mr. Bhattacharya made his submission. This has to be decided first.
Yes, 2nd December order where
Lordship.
issue raised in the application.
Lordship, Lordship, page 132 is the Lordship. Order dated 2nd December, Lordship. Lordship, in page 130. My application, Lordship, it's. আচ্ছা, Lordship,
এটার আগে, হ্যাঁ ঠিকই বের করেছে। এটার আগে এটার আগে কথাটা বলি। এর আগে ওইখানে এই যে
অন্যটাকে দেখতে হবে তাহলে।
2nd December 2025, Lordship. Running page 2, Lordship.
সেকেন্ড পিটিশন এই যে এটা
Second-
করেছিল
2nd December.
issue raised in the application will be considered.
And Lordship, kindly come to the last, Lordship, kindly come to the last line of the Lordship. Lordship, kindly come to the, sorry.
Different tinted department. Those who had appointed the orders of সেই জন্য প্রিয়ার করেছে ওই অর্ডার গুলো ব্যাড
মানে instead of filing appeal then it goes over.
হ্যাঁ এবং 439 হচ্ছে অ্যাপ্রুভ বাই ক্যাবিনেট
That is also there.
হ্যাঁ 313 is also
Without cabinet neither will it.
And Lordship, last line of the final judgment, Lordship. The connected application being CAM 6 2025 filed by the respondent number 7 and 8 are dismissed without any order as to cause. Lordship, I was not permitted to place this CAM 6.
what was your all those grievances you have to go back to the single judge. What we are wanting to know is CAN 6 of 2025 was the
Fine.
application for maintainability.
Challenging maintainability, Lordship. Filed on 23rd September 2025. Lordship, it was never heard. It appeared all throughout the length and breadth of the matter,
So
Lordship.
why didn't you tell the court?
Lordship, I told. Lordship, kindly look at the 2nd December order,
It's
Lordship.
a mixed question of.
The 2nd December, Lordship was pleased to record that this matter will be decided at the final
The
disposal.
maintainability point was kept open.
Open initially, Lordship, on 2nd December.
Yes.
But on 17th December, without any discussion, this CAM 6 are dismissed without any order as to cost, without any discussion, without giving me any chance to make. And Lordship, one thing, Lordship, kindly go through, Lordship, prayer B of the petition, Lordship. It is not only in case this 439 and 311. Lordship, the chart, Lordship, just shown, Lordship, in 86 of the earlier.
You were also within this 330
13. Lordship, my submission is, Lordship,
prayer? Which
prayer
prayer?
B of the writ petition, Lordship.
Yes.
Lordship, it says anybody whose service has been regularized post 30th July 2010 shall be set aside. Now, Lordship, then all these persons are required to be made parties. Lordship, they have only 313 has been, Lordship, notified.
ওই রিট পিটিশনটা করতে যাবে একটা রিট পিটিশনের কপি ম্যানেজ করছে পেজ ওই এই জিটি এর অ্যাপিলে পেজ
Page 117
117
of Malot 7, item number 7. GTA appeal. GTA appeal.
Lordship, prayer B, Lordship, at 117, Lordship, it says, issue a writ, such and such, Lordship, by setting aside regularization of all teachers who have been appointed after July 30, 2010 in GTA areas. Lordship, they have not been made parties. Lordship, it was one of my points, Lordship, in this maintainability, in my challenge to the maintainability petition. Lordship, in the order sheet, Lordship, learned Honorable Justice has communicated to only 313 voluntary teachers. There was an order, Lordship, where the GTA was directed to communicate to only these 313.
you are concerned about your employment or you are concerned about others' employment?
Lordship, I am concerned that out of
You have been implemented.
out of all these things, why I should be selectively targeted?
That is an issue of 313 which has been argued. You are falling within 313.
Yes, but I am also,
You have been allowed.
Lordship, I am also-
So what maintainability you learn?
Lordship, I have so many, Lordship, my maintainability petition, Lordship, it is not dependent.
No, you are saying that those other persons, my friends of mine, are not engaged here. So how they will get information? Then the end
Lordship, what I say,
that
Lordship,
argument is not acceptable.
Lordship, that maybe, Lordship, maybe I have to substantiate in the single bench, Lordship. I have-
No, this is your grievance is related to your appointment, and your grievance is related to your friends who have coming within 313. So how if the 434 and others not added, or whoever had been appointed in derogation of 30th July, unless you include them, then no writ petition can be filed in High Court.
Lordship, Lordship, I have found, Lordship, some of the case laws.
Yeah, all
Lordship.
right. Now, please tell us what is the stand of the state? What is your stand?
Led by learned AG Malot is appearing virtually Malot.
Where is Mr. Reggie?
Mr. Dotto Malot,
But Mr. Dotto is on leg in a continuing matter, but with the permission of my learned senior there, if I may submit this, so the stand of the state, as far as the interim order is concerned, the matter requires an extensive hearing because all the affidavits are there on your lordship's record. So, to tie
Now,
over
are
the
you
situation as far
supporting
as
are you supporting their engagement or you are not supporting their engagement?
the stand, I'll have to show from the affidavit. It's
No,
clearly
we
written.
are asking you a question. What
I'll
is
tell
your
you.
stand?
I'll tell you the. As per my affidavit, which we have filed before the Honorable Single Judge, we were contemplating regularizing the 313 volunteer teachers. We had sent a letter, which was one of the impugned letters, which has been set aside by the Honorable Single Judge, 8th of March 2019. This letter, according to us, was only an in-principle approval awaiting the decision by the cabinet. Your lordship has found, already, as my learned seniors have submitted for all the parties, there were earlier rounds of regularization also, which has been approved by the cabinet. As far as this last batch of 313 was concerned, the approval of the cabinet was still awaited. But we cannot shy away from the factual situation that we had contemplated a decision to be taken by the cabinet as far as the approval of this, as far as regularization of the 313 teachers are concerned. That is one. Number two, why did we contemplate at all? Because, my lord, contemporaneously, and even when this particular matter was pending before the Honorable Single Judge, coordinate benches and earlier coordinate benches have all directed the state to regularize the appointment of the volunteer teachers. All those orders, my lord, which has been given by this Honorable Court, have been annexed to our affidavit in opposition, where we wanted to demonstrate that the contemplation of the state is not something that we have not been earlier directed by the Honorable Court itself. Even when the matter was pending before the Honorable Single Judge in the Jalpaiguri Circuit Bench, my lord, we were directed to regularize certain teachers.
We are asking a simple question. We are asking that if your contemplation and everything goes, what is your stand? That are you beside the teachers, or you are saying that you send them home, they are not required in service because it is a backdoor appointment? You are the state. You are still
Malad-
feeding the teachers by sanctioning grants.
but not through the education department. Malad, that is a separate.
Mr. Bandyopadhyay, today the salaries which they are getting, can
Yes.
you say that the state
I'll
has
tell
no
you.
part to play in that?
I cannot
Certainly
say
they
that.
have.
No, but
So
the factual, your lordship will kindly hear me on the factual situation. Unlike Malad, other teachers, where the payment is made from the education department itself. Malad, as far as GTA is concerned, it is a consolidated grant made to GTA by the Home and Hill Affairs department. It is not through the education department
So when your
where we
home
can
and
verify.
hill, so when your home and hill department is giving the money, this consolidated fund, one hand you give the
Yes.
money and next hand you say, I am not acting in principle. I made a general declaration, I am not going by it. So you yourself are
where this
following a dubious process. State itself is not
Malad,
sure.
where the consolidated fund is being apportioned, Malad, it is not that we are apportioning it and giving it, saying that you pay the 313 volunteer teachers. It's a different process as far as the GTA
That
area
is
is
exactly
concerned.
so we are questioning you. You take, we will note it in the order that either you support or you do not support. You cannot take any middle path. That I am there, I am contemplating. What is your stand? What is your stand? Tell us
May
that
I
no, no, I
show?
will stop the salary
May
from
I?
tomorrow.
May I show one sentence from my affidavit, if your lordship permits
You are
me?
not
One
answering
sentence.
our query, Mr. Bondu.
The answer is in the affidavit. Kindly takes
No,
one
no, you
sentence
are
from
being
the affidavit.
anticipative that what I
Page,
will say.
page 322. Kindly takes volume 3, page 322.
Yes, tell us what is that. 322.
322 paragraph 9. It is our stand there that I state at the cost of
322
of the item number 7.
বাবা এটা বের করে দাও নাই 300 এখানে সব মিলিয়ে যাচ্ছে এটা ওই এই ম্যাটারটা 7 এর আইটেম নাম্বার 7 এর 332 you said
322.
না ওটা জিটিএ ওটাতে থাকবে না এই যে
110, MAT 110.
প্যারাগ্রাফ 9
Paragraph 9, Paragraph 9.
yes yes what you are saying
Kindly takes the sentence from the fourth line from the top. 322, volume 3, para 9. I state at the cost of repetition that the answering respondent number 1 had communicated their intention to regularize the service of 313 volunteer teachers against the physically verified list of 313 volunteer teachers by DI by Representative so-and-so, subject to the receipt of evaluation and financial implication to be received from the Commissioner of School Education. However, since such impact assessment report was still awaited, any appointment made by the DI Darjeeling without the consent and or knowledge of the answering respondent number 1 is the owners of the DI Darjeeling, since the DI of School Darjeeling was well aware of the fact that the letter dated 8th of March 2019 issued by the School Education Department was not in the nature of final approval, as would be evident from the communication dated so-and-so issued by the DI Darjeeling. Hence, the answering respondent is not in a position to provide the details of so-and-so. Therefore, this is our exact stand that it was awaiting a cabinet approval. Allow করছো? My lord, your lordship's court officer may also allow Miss Learned Advocate General to join, my lord. He has already applied to join, my lord. And my lord, secondly,
Yes, you are.
irrespective of this part, we had also taken a point of locus of the writ petitioners. My lord, that point, my lord, since it was being discussed, my lord, that point has been decided by the
Yes, where
honorable.
is the Advocate General? Put him in online. Where is your Advocate General? Has he
My lord, he
joined?
has applied to join, my lord. He has applied to join.
So he has applied there and he has then applied to you that till the court.
My lord, he was on legs. Before your lordship's neighboring court, my lord, he was on legs, my lord.
Huh?
Join করেছো?
This is what Mr. Dotto will also submit. I think you
Yes,
must
he
have
may-
done.
He may,
Where
my
is he?
lord, my lord, he is.
We don't find him.
My lord, the court officer has to allow him to join, my lord.
না না আমার বলা পাওয়া যাচ্ছে বলা পাওয়া যাচ্ছে
He has been allowed.
এই তো,
লিঙ্কের প্রবলেম হচ্ছে নাকি?
কোনো problem না।
এখানে allowed।
Yes, Mr. Dotto.
But I'm sorry, Milord.
No, you first ask from Mr. Bandyopadhyay what he has submitted. Now he
Yes,
can
sir. What
submit
he has
something.
submitted, Lord, has been recorded by the learned single judge, Milord, in page 12 of the order under appeal. Please have,
Para?
please come. Page 12, subparagraph Roman 4.
No, internal page হচ্ছে।
Yes, page 12.
Roman 4, kindly have a look.
Yes.
Milord, his lordship was recording the submissions for the state. Roman 4 says the state is expressly denying allegations of illegal appointments, opaque or arbitrary selection, nepotism or favoritism, corruption or abuse of authority, wrongful backdoor entry in regularizing the engagement of the voluntary teachers. The letter dated 8th of March was an in-principle approval awaiting final approval. The said letter clearly demonstrates that the Chairman Board of Administration GTA was directed to approve the matter in consultation with the Commissioner of School Education, who would coordinate with the Director of School Education. The state came to know of the appointments for the affidavit filed by the GTA in a connected matter, which was withdrawing subsequently. Then kindly take back the Roman 5. No illegal list was prepared, no clandestine process was adopted, no large-scale regularization had occurred, and no appointments were made without procedural examination. The state in its affidavit has relied on various orders of the Honorable High Court by which directions were passed to approve the appointments of voluntary teachers from time to time, and some similar orders have been passed during the pendency of the writ petitions. Therefore, the state action in granting in-principle approval is in similar line as directed by the Honorable Court in various writ petitions cutting across more than last decade. It is impossible, so and so. Now, Milord, 2 or 3 documents, Milord, the lordships may kindly have a look. The first, Milord, I would be, Milord, referring to, Milord, the appeal filed by GTA. I have the copy of that appeal with me.
Oh, Mr. Dotto, we got your answer. We are passing our orders. Anything, we have heard them extensively, Mr. Dotto.
Very good. Milord, we had a point of focus. I believe, Milord, the lordship would be hearing those, Milord, at the time of final hearing.
We thought without an interim order that we will decide.
Yes. That is for your lordships to consider, Milord. But the only thing that I can.
কালকে অর্ডারটা
কালকে রাখতেই হবে অথবা দুটোর সময় রাখতে হবে।
দুটোর সময় কি সিঙ্গেল বেঞ্চে
সিঙ্গেল বেঞ্চ কি কোথায় দুটোর সময় রেখে দিন তাহলে হ্যাঁ দুটোর সময় অর্ডারটা দেওয়ার জন্য রাখা সেটাই বলছি। আপনি কি অসুবিধা আমি চাই চেম্বারে গিয়ে কথাবার্তা বললেন।
May I just add one line, Lordship? In my map 106, Lordship, I have, Lordship, shown that my clients were not given the documents, Lordship, on which, Lordship, I am to rely on. So Lordship, this order Lordship may not bind Lordship this applicant Lordship. Matt one.
No, we will take up those three, all the three matters we are taking up together. We'll pass
Common
out.
order, by a common order.
Lordship, my contention Lordship in 106 was that Lordship, my client didn't get the documents Lordship, upon which Lordship we can answer.
We pass our orders tomorrow, Mr. Bhattacharya, we have to. It will be the first matter tomorrow, we will pass our orders.
Give the oblige.
Ajay, hardly learned.
Milord, before your lordships rise, Milord,
We will just pass the, because 2 PM we have a bench. Within 15 minutes, I don't think it will be possible.
কালকে রেখে দিন।
Our presence may not be required.
Tell your juniors to be present if necessary for clarification.
No, we have heard Mr. Bhattacharya, Mr. Shamim, and all we have heard. We will not be inviting further argument. We will pass our order. এই টু কালকে 10:30টার সময় ফিক্স করে দেব। Thank you, sir.
Milord, could I Milord take this indulgence, Milord, to mention Milord item number 14.
ওই দেখো, right. No
But the
indulgence.
problem is, Milord, Milord, I'll be very Milord, Milord, with apology, Milord, may I make this submission?
Take your lordship kindly, man. Kindly.
Yeah, just order title লিখে দাও। All the above appeals are, all the above appeals involves identical questions of law, questions of law. And identical questions, identical question of law. And as such, the same are taken up for analogous hearing.
Common judgment has common
No,
judgment.
no, no. What are you in second? Your appeal is against 2nd December order. So the appeal are taken up for hearing, taken up for analogous hearing. Hardly learned advocates appearing for the respective parties. Stop. List the matter. List the matter as for orders in the daily supplementary list of this court on 23 তারিখ, on 24th, on 24th.
But so far as item number 14 is concerned, Milord, kindly Milord, give me this indulgence.
Mr. Dotto, we cannot take it up just.
Well, only thing, Milord, what has happened, Milord, may I only inform the appeal court, Milord? Where the matter is appearing, Milord, before the learned single judge today. It was called on about 10 minutes back. But I requested the learned single judge not to take up the matter because the appeal is pending. But the learned single judge overrules my objection. I said that if you pass any further orders, my appeal would become infructuous. Recording that, Milord, the learned single judge passes further orders. Now, where am I to go? Well, I cannot regulate the court's proceeding. Now,
So
please
where is
consider
the-
this.
Who
Even
is
the-
your other side here?
Mr. Vikas Ranjan Bhattacharya is appealing for the petitioner in that matter also.
Yes, I'm there for the petitioner. Learned
But how
Singhal
could it be?
didn't pass-
This
Didn't
is-
pass any
this is
order
with
which might
respect,
affect the
Milord.
pending appeal.
Milord, this is with respect, Milord,
With
judicial
the best of
indiscipline.
respect, Learned Advocate General has misled himself. Learned Court did not pass any order which will affect the pending appeal in any
No,
manner.
Milord, the learned single judge has called for records of an inquiry to
That
pass
doesn't
further
relate to
orders.
the appeal. That doesn't
The
relate to the
learned single
appeal.
judge
বল
says
তাড়াতাড়ি বল তাড়াতাড়ি বল
that I
মামলা
will
তো
act on the matter, but I will pass an injunction.
So order has
These-
been
these-
passed,
these-
na?
These are, Milord, some unpalatable comments, Milord, which, Milord, does not go with the traditions of our,
No,
of
no,
our court.
Mr. Dotto, what ultimately the single judge has done?
Milord, the
Nothing,
learned
only-
single judge has called for
Passed a
Milord,
fresh order.
Passed a
Passed
fresh order. Fresh order.
What is the order? Then we have to go into it, Mr. Now the matter has been
Milord,
kept.
Milord, please keep it, Milord, as the first matter tomorrow. I can understand, Milord, your lordships have many other business, but Milord, my appeal cannot be made infructuous in this manner. Please take it up as the first matter tomorrow, again, Milord, subject to the business permitting. I
So
cannot,
first we
Milord.
will pass orders on this. We have to
Very
pass
good.
orders on this. Thereafter, if time, when is the next date fixed by the learned judge?
Tomorrow. Again tomorrow.
Otherwise,
So
my
I
heat would
request-
become infructuous.
Milord, no order has
Because the
been passed.
state has
Milord,
many
Milord,
machineries. They prefer appeal
how
from
can-
each
how
and
can
every
a-
order. My
my lord,
appeal would be
liquor
it
license,
become
I
Lord,
think
infructuous.
only
suspended.
passed over has been done, Lord. Today, the matter has been passed over to
No, it has
enable the
not been passed over.
authority,
Mr. Shamim Ahmed,
enable the
Lord, Mr.
authority,
Shamim
Lord, to
Ahmed, will kindly
produce.
not
All
mislead
right,
the
all
court.
right, we
In
will,
the-
Mr. Both of you are here. We will keep it as the second matter after these
After,
three.
yes, yes.
But only this understanding, kindly, my lord, Mr. Bhattacharya is here. We have great respect for him. If, my lord, by the time your lordship takes up this matter, if the single bench matter is called on, my lord, we'll jointly pray for an
No,
adjournment.
that's why,
before the
Lord,
matter is
that's why, Lord, to correct the facts, Lord.
Yes.
The matter has been passed
Single
over
judge
to
No,
the
no,
next.
Mr. Dotto, you submit. We have
This is
completed. We have to pass
unfortunate
on
that
the
some
report.
my lord,
allegation
we
is
have
raised
made
against the
this
judge.
submission.
Very
My
unfortunate.
lord, if this submission is overruled by the
This
court,
is something aspersion of the
what
court.
can I do?
এটাকে উপরে উঠিয়ে দিয়ে আর কি। Item number
1-4.
Item number 4.
item number 14 টাকে তুমি এই তিনটে অর্ডারের ম্যাটারের পরেই
I'm grateful.
give it. It is it not sufficient?
Just a day. I will. Your notes not
Chef, one of the 11th
one shot. Two officer will come to Dr. One.
Fortunately, this is happening always in these recruitment cases.
সবের excellency এর সঙ্গে।
হ্যাঁ
Lordship, before you rising, Lordship may kindly take up the item number 10 as there is some urgency.
item number that securitization matter.
Lordship,
It will be there. Which is your item?
10.
Item number 9. Item number 9.
Item number
Item number 9, Lordship.
ওটাকে ওটার পরে রেখে দিন।
Lordship, deeply obliged.
Supplementary affidavit, the first order, dated, my lord, 11th of.
Show me the letter by which the petitioner was directed to produce bank guarantee.
My lord?
Because he says that there is no.
Yes, I'm
want to show that. The petitioner was asked to produce a bank guarantee instead of a bond.
my lord, this letter is not there.
This is an admission in the medical college.
Yes.
There are certain guidelines which has to be followed.
Ma'am.
I cannot say that you being such and such cash and deposit in my counter, in the college counter.
It is not that, it is not that.
Where is that statutory rule to produce the bank guarantee instead of bank bond? They say that there is no such statutory rule. One has to come with a bond and furnish the
Yes,
bond
my
for
lord,
the author.
my lord, kindly see, my lord. After filing the writ, kindly have a order dated 20th of November 2025. My lord, kindly see the supplementary affidavit, sorry. The, my lord, the order which has been passed, disposing of the writ petition.
Page number?
My lord,
12 November order.
12 November order, my lord. This is the order dated 12th November 2025. My lord, there is no denial also. There is no denial on the part of the respondent. Kindly have a look at, my lord, the order. The affidavit of the service such and such, the petitioner being the successful candidate of the need such and such, had participated in the counselling conducted by the medical counselling committee of the respondent number 3 herein for the admission of the medical course in West Bengal. In the third round of the counselling, the petitioner was allotted such and such, Durgapur, the respondent number 8 herein under the unreserved category against the state quota, but he was denied the admission purportedly for the failure of the furnish of the bank guarantee. Such and such learned advocate of the petitioner submits that to get the admission of the allotted college is obliged to furnish bond, not the bank guarantee.
Yes.
Then, my lord, their submission.
Please read my submission. Please read my submission. Please read.
I did not interject.
Please
I
read
did
that.
not interject. You have
misleading the
skipped.
court,
No,
please.
I am not. I have not been misled. I have not misled. I did not interject. No, I will not read.
Should I release the matter?
It has been said that I have accepted. I have said what
Why
is-
he dictate?
This
He will
sort of
dictate in which
thing
manner.
goes on. Either address to the court.
Yes.
Mr.
He is
Chakraborty, please
dictating me,
take
my
your
lord. He
seat.
is dictating me that we have to read.
Please address the court.
I did not interject, my lord, while he was, my lord, submitting.
Yes.
Then, my lord, kindly see their submission has been mentioned. Then the petitioner is directed to approach the respondent number 3 and 8 with the said original bond to complete the admission process, and the respondent number 8 upon the production of the said original bond and upon compliance with the other formalities shall admit the petitioner, and thereafter the respondent number 3 shall regularize the said admission. So this is the order. After, my lord, passing this order, when the bond has been furnished on that day itself, whatever may be the, my lord, the authenticity of the bond, they file, my lord, an application recalling the said order. This is, my lord, Can 1. So what is the scope of the Can 1? What is the prayer of the Can 1? Kindly have a look at, my lord. Kindly have a look at page 13. Well, got it?
Wait, yes. Yes, Can 1, page 14.
13, my lord.
Yes.
In the premises as aforesaid, your lordship was graciously be pleased to issue a rule calling upon the writ petitioner and the other respondent to show cause as to why the order dated 12th November 2025. His principal prayer, 12 November 2025, passed by the lordship such and such, shall not be recalled, and the writ petition shall not be dismissed with cause, and or cause being shown, or if no cause is shown, to make the rule absolute, pass such other order or orders, and ad interim order in the terms of the above, my lord, the prayer. So principal prayer is recalling of the order dated 12th November 2025. Court passed an order staying this order. Kindly have a look at. No, just 17 November 2025 order.
The affidavits in the writ petitions have been filed.
No. A writ petition was disposed of on the
Writ
first.
petition has been disposed of, and
All the affidavits and the supplementaries pertaining to the Can 1 application.
not in the writ. Writ petition has already been disposed of, my lord.
And the affidavits are only with regard to supplementary, no affidavit filed against the application. It's only against the supplementary affidavit.
Now you are referring to which, sir?
My lord, the order dated, my lord, 17th of November 2025.
Yes.
Kindly have a look at, my lord, page 3. No, prior to that, my lord, page 2. My lord, there was a principal allegation in the, my lord, their application for the recalling that the forged document has been submitted. At that stage, it was simpliciter an allegation. Since this is an allegation, therefore, court passed a direction to file an FIR, and on the basis of which the matter can be investigated with. If it is appears that in the criminal investigation department, there is a finding that the forged document has been obtained, and there is a contribution on the part of the student concerned, in that event, you know, the admission which would be given, that would not be given effect to. This is the basic principle. So, you know, it has been stated, page 2 in the order dated 17th of November, the Mr. Chatterjee learned senior advocate, the last parameter, Mr. Chatterjee learned senior advocate for the petitioner submits that petitioner is not shying away from any investigation, but the allegation is yet to be proved at this stage. The college should not put the career of the bright student like a petitioner at stake. Heard the learned counsel of the parties, peruse the materials on record. In view of the letter, being number such and such, dated November 14, 2025, the head clerk of the office of the chief judicial magistrate, being the first class judicial such and such, a prima facie doubt regarding the genuinity of the bond executed by the petitioner has been created. Therefore, the direction of the court upon the West Bengal Medical Council Committee and the college authority respondent number 3 and 8, respectively, to complete the admission process of the petitioner upon production of the said bond shall remain state until further order. The respondent number 8 is directed to lodge a formal complaint with the jurisdictional police station, Bhavanipur police station, regarding the alleged act of forgery in execution of the said bond. The original bond produced by such and such and over the Mr. Chakraborty for keeping the same in the custody of the respondent number 8 college, so long it is not requisitioned by the police authority, photocopy thereof be kept with the record, the application for the fire directions be listed such and such. Then, my lord, kindly have a look at the order dated 20th of November 2025. My lord, I will place, my lord, the third page, my lord, of the said order. which has been challenged subsequently before the division bench. Heard the learned counsel for the parties, peruse the material on record. Today, in the last date of the admission, the bond produced by the petitioner to get admission prima facie appears to be forged document. So, court is conscious of the fact the document which has been produced is a forged document. However, the involvement of the petitioner in the act of such forgery is yet to be established. Therefore, it will be inequitable to deny his admission at this stage. Court is conscious of the fact the document has been forged. Court is also conscious of the fact that what is his role to be played has to be ascertained by the investigating agency. The respondent number 3 and 8 are directed to complete the provisional admission of the petitioner subject to the production of the fresh bond within the scheduled time today, and subject to the prima facie satisfaction of the respondent number 8 regarding the veracity and the format of the said bond. So the principal thing which is required to be considered, that the respondent has been directed. Then next para, the admission of the petitioner, there is a rider. The admission of the petitioner is subject to the final outcome of the pending criminal proceeding, not format, pending criminal proceeding. In the event the petitioner is found guilty, the said criminal case, his candidature seat allotment shall be cancelled with immediate effect, and in such event, the petitioner will liable to compensate the college as per the bond. So two aspect has been taken care of. If there is a cancellation, if he is found guilty, in that event there would be a cancellation of their admission. At the same time, he would be obliged to recompense the loss sustained by the bank, sustained by the institution. So both things has been taken care of. This is equitable order. The petitioner, if he fails to produce the fresh bond today within the stipulated time, the direction of the block of the seats allotted to the petitioner shall stands vacated. Such and such shall be at liberty to put the seat in the next round of the counselling, such and such. Next is important. The DIG CID West Bengal is requested to take over the said Alipur police station case number such and such dated such and such immediately. A progress report of the investigation be filed before this court on the next date of hearing. So court is also, my lord, conscious of the fact that would be the development of the investigation to be proceeded with. So that's why the matter has not been disposed of. The matter is listed on such and such, parties to act on the server copy of the order, downloaded in the official website, urgent photostat certified copy. This order has been, my lord, propriety of this order has been challenged before the Honorable Division Bench. This has been argued at length. I was there. It has been argued on length. And, my lord, subsequently, kindly have a look at, my lord.
Yes.
Page 2. Page 2, my lord, of the order dated 26th of November 2025.
Just now he handed over a copy. You have a copy.
Miller, I do have set. Kindly see. This is the set of, Miller, all the orders. This is the set of all the orders, Miller. Your lordship will get it chronologically. This is order dated 26th of November 2025. Passed by the Honorable Division Bench. May I refer, Miller? Miller, kindly have a look at page 2. Mr. Kaur, second paragraph. Mr. Kaur, the learned senior counsel, who appeared for the appellant, appearing for the appellant, submit that the bond which was produced by the writ petitioner at the time of the hearing of the writ petition on the 12th November 2025 was a forged document, as would be explicit from the documents annexed to the pages 102 and 103 of the stay application. Having produced the such forged document, the writ petition could not have been claimed any equity, and the learned judge erred in law in exercising the discretion in favor of the writ petitioner. He submits that the learned single judge erred in law in directing the admission beyond the mandatory period specified in the such admission on the 6th of November 2025 and 8th of November 25 till 4 p.m. Such and such learned advocate appearing for the writ petitioner, the respondent number 1, denies and disputes the contention of Mr. Kaur and submits that there is no infirmity in the order impugned, inasmuch as the learned single judge has categorically made it clear that the provisional admission as directed would be subject to the outcome of the investigation in Alipur police station case number such and such. In reply to such and such, Mr. Kaur submits that the bond which was furnished by the writ petitioner pursuant to the order dated 20th November 2025 was not in form and not in consonance with the direction contained in the order. So this issue has been agitated that this is not in proper format before the Honorable Division Bench. Answering the query, Mr. Maiti, learned advocate appearing for the university, submits that the counseling process has already been completed. We have heard the learned advocates appearing for the respective parties and considered the material on record. By the impugned order, the learned single judge, this is important. By the impugned order, the learned single judge has directed the admission of the writ petitioner subject to the final outcome of the criminal proceeding. Pursuant to the such direction, the writ petitioner proceed a fresh bond before the appellant and he granted provisional admission. It thus appears that the order has been acted upon. Furthermore, the record should reveal that the writ petitioner has been made returnable tomorrow, 26th of November 2025, under heading to be mentioned. In this conspectus, we are not inclined to interfere with the order impugned, and accordingly the appeal along with the connected application is dismissed. So everything has been considered. It is, however, made it clear that the dismissal of the appeal shall not prevent the appellant to advance the argument and such, and then there is no order as to costs. So that has been mentioned. So, my lord, all these points that this is not in proper format has been taken care of, that has been argued before the Honorable Division Bench, and Honorable Division Bench is conscious of the fact that investigation is on and that consideration is also there. Then, my lord, kindly see the order in the can. At page 27th of November 2025. Yes. The supplementary, then, my lord, the scope of the can 1 has intended to be expanded when they did not get any order before the appellate court by filing a supplementary affidavit. What was the proposition? That, my lord, the subsequent bond which has been submitted not in proper format, although that bond has been examined by them. A supplementary affidavit is filed on behalf of the such and such is be kept with the record. The petitioner is a successful candidate of such and such, was allotted with the seat of such and such, respondent number 8 hearing. The bond submitted by the petitioner at the time of the taking admission of the said college was found to be forged document. The college by the present application has brought the said fact on the record. Court by the order dated November 20, 2025 has directed the college to lodge a complaint with the concerned police station. The college, in compliance with the said direction, has lodged the said complaint giving rise to the Alipur PS station case number such and such. The said criminal case in the terms of the direction of the court is taken by the DIG CID West Bengal. A progress report of the said criminal case in a sealed cover that has not been opened, that has been placed before this honorable court, is filed on behalf of the state. Let it be kept with the record. Court, however, by the order dated November 20, 2025 has directed provisional admission of the petitioner subject to the production of the fresh bond within the scheduled time and subject to the prima facie satisfaction of the college regarding the veracity of the format of the said bond. The college of the supplementary affidavit filed today, alleging that though a new bond was submitted by the petitioner on November 20, 2025, but the same was not in the proper form, but to comply with the direction of the court, the petitioner was given provisional admission. It was not the order. Order was, having been satisfied with the format, you give admission, provisional admission. Then, my lord, the submission of the Mr. Kaur has been mentioned. The Kaur, the learned senior advocate for the counselling, submit that the new bond is defective as both the parents did not put their signature in the said document. As such, the said bond is not a proper, and as such, on the basis of the said bond, the petitioner cannot be admitted. His praise immediate suspension of the admission of the petitioner. On that submission, my lord, father and mother of the student has given a subsequent bond, where, my lord, father's signature is there, mother's signature is not there. What was the bond? It is nothing but the indemnity as per, my lord, the section 126 of the Contract Act. So it has been stated 124. So it has been stated that if he is having any property, he has to give it as a collateral security. The property which has been given, that is not stand in the name of the mother, that is stands in the name of the father. So they erroneously, my lord, since, my lord, he is a day labor. Since he is a day labor, my lord, he is not in a position. He has to approach the learned advocate. If the learned advocate in what manner they will guide, he has to do it. So what he is staying, my lord, he is doing in Calcutta, in Durgapur, in Baharampur, we are not aware of the fact. Only see, Mr. Aniruddha Chatterjee, learned senior advocate of the petitioner, submits that the petitioner at least is entitled to chance to controvert the allegation of the supplementary affidavit before any penalty is imposed. So since my lord further allegation has been made, an opportunity has been sought for as to why the allegation has been made. Then my lord, this is the observation. The admission of the petitioner is provisional. The acceptability of the bond produced by the petitioner to get such admission needs to be decided first before cancelling the such admission. Therefore, the prayer of Mr. Kaur for immediate suspension of the provisional admission of the petitioner at this stage is refused. The petitioner is directed to affirm an affidavit in opposition and such to that effect. So kindly take, my lord, there, my lord, supplementary affidavit. My lord, similar matter has been taken up, Justice Basu, and passed an order where the similar issue was cropped up. He belongs to a marginal section of the society, where my lord, the similar issue has been came up before the consideration, where my lord, the father has filed a bond which has been accepted by the college and court and passed an order. This is the similar order. So it is not required that father and mother has to file the bond. The property stands in the name of the father. He would be the guarantor, not the mother would be the guarantor. But it দিয়ে দিচ্ছে একটু দেখে আমি তোকে দিয়ে দিচ্ছি
At least give me the number of the case that you can say.
এক্ষুনি তোমাকে জজ সাহেব দেখার পরে দিয়ে দিচ্ছি
I'll check from the online. You don't have to give me the date.
না আমি কোনো ফোর্জ ডকুমেন্ট দিচ্ছি না
Your client can give, no? That's his conduct. Please tell me the case number. Let me check from the website.
Which paragraph?
মিলোর আরেকটা কপি আছে ও মিলোর দি
Check and tell me.
হ্যাঁ কেস নাম্বারটা নিয়ে নাও 27446 of 2025.
The candidate has the choice preference of giving a bank guarantee or a bond. My lord, I am representing WBMCC. We have a notification dated 7th August 2025. Roman 2. My lord, I will hand up my tab. I don't have a printed version. Sorry, my lord. It is written clearly, candidates who are getting admission in private college, trust colleges, central institutes have to submit the bond / bank guarantee as per requirement of the said college. In
requirement
that
of the
it's written, preference to be given to candidate's choice for providing bond or bank guarantee. So it is basically the candidate's choice.
So there is a provision for giving bank guarantee as well as but they insisted, my lord. That's why a person will not come and my lord, they knock the door of the court.
What the MCC is referring, this is the notification.
My lord, 11, 12, 13. 11 onwards.
কত তারিখের অর্ডারটা দেখাচ্ছ তুমি অর্ডারটা যেটা
My lord, Roman 2 at the end of the first page.
11th of December 2025.
Roman 2.
Candidates who are getting admission in private colleges, trust colleges, central institutes have to submit the bond / bank guarantee as per
So there is a provision of the two things. So that's why they have insisted.
It is as per the choice.
he had to show that he had a bond to show that we have
So, my
insisted.
lord, nobody will not knock the door of the
Submitted
court.
that there is a statutory norms that one has to submit bond.
Yes, that I have shown me on page 53 of the writ petition. That the bond he has to
Kindly
come.
see the paragraph 11 onwards, my lord. Paragraph 11 onwards. Where, my lord, this provisional admission has been given. After giving the provisional admission, he filed a bond. This bond has been submitted by the father alone, and that has been accepted. And the pro forma which has been given, my lord, in other college, Jagannath such and such. Jagannath Gupta ki. This is the pro forma.
বন্ডের ইস্যুটা কোন প্যারাগ্রাফে দেওয়া আছে সুবোধ একটু বলবে
ওই 11 থেকে সব লেখা
You can stop. Stop here. We'll take the matters after the vacation. Heard Mr. Srijeev Chakraborty, learned advocate for the petitioner. Mr. Chakraborty, learned advocate for the, sorry, call this. Response number 8, nahi ho? Response number 8 submits that at the first instance, the bond which was submitted by the petitioner was primarily found to be forged. Upon scrutiny, though on the basis of the said bond produced in court, the writ petition was disposed of on
12th November 2025.
12th November 2025 on the assumption that the bond is in proper form. An application being, can one is that application for recall?
Can one of
Application being can 1 of 2025 was filed before the court for recalling of the order since the bond that was furnished was found to be false. The court directed for criminal investigation, which is under process. As per order, which order this provisional admission has been given?
20th November.
20th November 2025, provisional admission has been given to the petitioner, which is subject to the veracity of the bond
And format of the bond.
and veracity and format of the bond. Upon scrutiny, it is found that the bond has not been executed by both the guarantors.
My lord. My lord.
Both the guarantors, and as such, it is not in proper form. Since the order of this court for provisional admission has not been complied with in stricto sensu, the such provisional admission needs to be cancelled forthwith. Mr. So-and-so learned advocate, on the contrary, for the petition on the contrary, submits that the order granting provisional admission has taken care of the consequences which can crop up due to such admission. And it has categorically subjected such provisional admission to the outcome of the final outcome of the criminal proceedings.
My lord.
And furthermore, condition has been imposed that in the event the petitioner is found to be guilty, has to compensate the college authority. Similar submissions were advanced before the Honorable Division Bench as well as before the coordinate bench of this court, which has refused to cancel the provisional admission. A report has been furnished by the state. It is found that investigation is still going on. Since the provisional admission of the petitioner is subjected to the final outcome of the criminal proceedings, at this stage, it would division bench
The division bench has returned everything back to your lordships.
decide everything. It is now page 3.
No, order of compilation, my lord, this is order dated.
3.
Order dated 26th of November 2025.
When this, who is for the state?
State is আপনি কি আছে?
So what is the stage of investigation and when it's going to end?
My lord, it will take some time, but
How long?
all the culprits.
Culprits থেকে all the culprits. Accused বলুন।
It will take some time.
Sir, kindly specify the time because yes,
3 months.
what is the stage of investigation right now? How many persons have been, whether it has been sent to the
One person has been arrested, my lord, and investigation and the other members of the racket, as well as the trace of both seal and stamp, that is in progress. My lord, kindly come to my lord.
Report দিন না,
Three.
দেখে বলে দিন।
Paragraph 3, my lord. Of the report, my lord.
It has been observed in order dated 27th November 2025 that the acceptability bond produced by the petitioner to get such admission needs to be decided at the first instance before cancelling such admission. Accordingly, let the matter be fixed on. বলুন। January. Assign কবে নিচ্ছি? Thursday.
কবে?
Thursday is 8th of January.
8th of January, I'll take it up. You have concluded your argument with regard to the bond that is given.
Nothing. No, I have nothing more to say. Only one paragraph from the affidavit I will show that I could have shown today. I'll show it on 8th of January.
Miller, I am
Our
praying for the
endeavor, Lord, our endeavor is never to.
Regularize his admission then.
Why?
Lord, that is not that we are challenging. They cannot regularize it now.
How can
It's a provisional admission, my
Yes, they cannot be regularized. You know,
register his name on the portal.
Lord, your lordship is deciding the admissibility. Then it will tantamount to Lord dismissal of my application. What the state is saying, the court is Lord adjudicating.
No.
the issue.
Miller, may I submit? May I submit, Miller?
Lord,
Initially on 15th or 16th, Miller, he visited the college. Despite Miller, there is a provisional admission. He was not allowed to enter into the premises or precinct. Subsequent,
again, he is saying wrong things.
we are having Miller the document with me in supplementary affidavit. I will file.
I'll show
Then
the
Miller on 17th, he has been allowed. I have written. He visited college on 8th of December 2025. He has been refused to enter into. 10th of December 2025, he has refused to enter into. On 17th of December 2025, they asked me to come to the college. I went there. I have been allowed. Then, Miller, I have been allowed, allotted the hostel. Since then, from 17th, I am doing the Miller college.
Yes.
This is the Miller the development.
It is the duty of the college authority, my lord, as per
From the day
regulation
one.
made by the National Medical Commission. My lord, since it is the admission regarding my lord MBBS, my lord, it is the duty of the college authority to forward the name of the candidate who has got admitted.
But we are challenging the admission.
SSC Medical Counseling Committee.
They are not forwarding
We are challenging his admission.
Otherwise, if ultimately, my lord, the student is found not guilty, my lord, he will not be registered in the
University.
as well as the ultimate after.
Lord, we are challenging his admission. If that is done, then everything will go out of hand. We're challenging his basic admission.
was the order when it was found, any such submission was advanced
No,
before
no,
the
no,
court
no, no.
that this is a predicament
No.
to give a provisional admission. On the
No.
basis of provisional admission, there is no registration.
Nothing was said.
Since we are, my lord, on behalf of the respondent authority, we are trying to assist your lordship.
But they were there on
Come
that
up
day.
with a proposal, what to do then?
Yes.
But we
They have, he cancelled, the provisional admission cannot be granted as an admission.
Yes.
Because there are
then-
matters which is to be looked into.
Yes.
So, my lord, if my lord, they will forward the
kindly
name. That
consider
will
one
not create
thing.
any prejudice.
kindly
because
consider
he's
one
giving you
thing.
one.
Lord, kindly consider one thing.
But I have not decided it.
Yes, your lordship is deciding it. Now, how can the state comes up and say this? State,
student
Lord, the state has become very conscious about the student.
Lock the seat, my lord, for long.
State has become very concerned about the student. They did not come.
No,
They have
the
never
state has
taken a
to be,
step.
because the state is having
Yes.
parent
The matter is decided by the court.
Yes, still the matter is decided by the court. It could not be done. Not only one thing
My
can
lord,
they consider.
since
If
there was
Petitioner will come after us after certain point.
the matter is pending in court, why will you be obliged?
when my order has been given, he has not been allowed to enter into the my lord, the
Lord, that is a wrong
college.
statement.
No,
that is a
on
wrong
affidavit I can give it.
I will
because
also
I have
file an
taken
affidavit.
note.
Mr. Datta is
My lord, I
taking
have
a wrong statement.
taken written note, my lord,
But
from
I have also taken
because
a
we have sent, my lord. These are the mails. My lord,
Yes,
kindly
I have
see.
the copy of the mail. Email to
My lord, kindly see the
I have
mail.
a copy of
We
the
have sent it. We have been
Lord,
reviewed.
his phone was switched off for 10 days. He did not come.
ব্যবস্থা করে দিয়েছি।
Why we are fighting for this? Your lordship is keeping it after vacation. We can come and argue all
Kindly
this.
see the mails, my lord, we have sent.
We can come.
Not
Why?
see anything until and unless it is
Yes.
filed by
We'll
way
come
of
back
an
on the
affidavit.
8th of January.
File that.
Lord, we'll come back on 8th of January.
File a supplementary affidavit.
my lord.
Mr. So-and-so learned advocate submits that the petitioner has been prevented to attend college,
My lord.
Which we have denied. Which I am denying.
which is denied by Mr. Chakraborty, learned advocate for response number 8, College Authority.
Yes.
And, and subsequently, my lord, I have been allowed on 17th. On 17th.
Yes. I have prevented. I have allowed.
Yes, because my lord, I do have mail and I have to have intimation.
After the criminal case was registered, he switched off his phone
Filing
and
any
went there.
affidavit?
Yes.
My lord.
Will you be filing any affidavit?
So, my lord, this is not German over
No,
here.
my lord,
because
this is kindly let him file it. Yes. Then
No, I am showing the conduct, my lord. I am showing the conduct.
please look
In
into your
what manner
conduct.
they
You are
are,
a
my lord,
fraudster. If you had a fraud
No,
document
madam,
that
what is
came
the
to
technical problem? Since there is a order of this court,
Yes,
which everybody has to abide by that order.
Yes.
It says a final outcome as
Yes.
well as the veracity of the bond, which
Yes.
has not been decided. Now the affidavits have been filed. I am fixing a date on 8 to conclude the hearing
Yes.
with regard to the veracity of the bond.
My lord. My lord. On 8th of January, we will conclude the hearing.
What we take problem will be in the future is that the portals will get closed which are open right now. to the
That
government.
your lordship will direct for opening the portal if he succeeds. If he succeeds.
Only predicament.
Yes, your lordship will direct them.
Rights of the parties are involved. We cannot
Yes.
go by that
Absolutely.
timeline.
Your lordship will direct.
Decide. Let this.
No, that is for admission, not for registration.
As this case is concerned, since he has been provisionally admitted to the
Yes.
college,
Yes.
now the matter has to be decided by the court.
Yes.
Till such period, the provisional
Absolutely.
admission should be extended.
Yes. And I'm grateful to your lordship. Well, let us come back on 8th of January and we'll complete the
Instead,
argument.
my lord,
NMC and the WBMCC were
पूरा है तो
not
सब
thought that
कुछ
we will also
अच्छा.
register his name in the portal provisionally. Provisionally.
If the order goes against him,
We will
immediately
cancel
cancel.
because it's easier to file to cancel.
So what is the difficulty now? Let
no,
the court
they are not.
decide first.
They are not forwarding the name. They are not forwarding the name.
Lord, that is not the issue before my lord. Let us come back on 8th. That is not the issue. It is coming verbally from them. That is not the issue. Let them produce if anything is there. It's a provisional admission. We have challenged that.
So the provisional admission has been made.
Lord, the provisional admission has been made as per the court's order. Lord, as far as my limited knowledge, let me explain this. Lord, normally the admission is done through the online problem. His time of admission expired on 8th. Then he went there on 20th with
So
order
he,
of the
once again, my lord, he is
kindly admit, সময় দাও, বলি, আমি তো বলছি কোর্টকে। He went there on 20th for physical admission. So there was no online admission for him. We have physically, provisionally admitted him. And immediately on the next day, we have challenged his admission before your lordships. Now the Justice Basu said, let the provisional admission continue and the issue shall be decided. Now today, if your lordship directs that his admission shall be regularized, then that will tantamount to dismissal of my application.
There is no question of regularization.
No, no regularization. No regular. We are not seeking any
Lord,
regular.
one more thing. Lord, one more thing. One more thing.
Provisional
One more
entry
thing.
into the formalities.
One
That
more
would
thing.
be did provisional.
With regard to the, I do not know why the state has become state.
See, you maintain these circumstances which was before Justice Basu. We'll continue on 8th.
Yes.
Conclude your hearing and we'll decide on this.
Yes.
As.
Instead of 8th, can it be the 9th or any day 9th? Because I'm 9th, if your lordship pleases. 9th আছে দেখুন তো একটু প্লিজ।
9th না 9th না।
My lord, then 6th.
না না 6
wait মানডে তে দিয়ে দেবো হ্যাঁ
13 করুন
12th
আজকে তো টুইসডে
on 13th Mr.
Kindly make it on 10th because up to 11th the portal is open.
10th is a Sunday or Saturday.
Then 9th করো portal open.
শুভদার ম্যানেজ করো না 8 তারিখ দেখো
Portal open.
9 তারিখ করুন 9 তারিখ করুন
No, 9th, my lord, make it 9th. Make it 9th, my lord.
Lord, I'm here every day. I'm here every day, my lord, whenever my lord calls me. Lord, our endeavor is to clean the system. We are not against anybody.
Okay.
If he had not come with on the first day, what Mr. Dottu was saying, I only impressed upon the college that you give him admission. Because I thought it was a genuine bot. Lord, a person, if this goes on, Lord, our apprehension is this goes on, from next year onwards, this will become a trend. People will forge documents,
Apart from
get-
this, my lord, other
get
matters
admission,
also been done. The
get admission,
similar sustain.
and then say that subject to the result of the criminal will never end.
লেখার জন্য how long you will take to conclude?
My lord, half an hour.
Yesterday he said 5 minutes.
Lord, for
আপনি
me,
এগিয়ে নিন তাহলে সুবিধা হবে হ্যাঁ 9th is last date একটু এগিয়ে নি তাহলে on 6th sir who was having problem on 8th
6th, my lord, 6th.
Huh?
6th.
6th
always in front of your lordships.